My parents threw a family reunion with 120 guests just to announce they were removing me from the family and giving me my sister's $340,000 lawsuit. My brother laughed, "Take the trash with you." I left quietly. 4 days later, Mom was crying outside my door. The morning of the reunion, I made a potato salad. That is the detail I keep coming back to, even now. I spent 45 minutes on it the night before, the right kind of mustard, the red onion soaked in cold water so it wouldn't be too sharp, the eggs cooked exactly the way my grandmother taught me. I put it in a glass bowl with a lid, set it in the back seat of my car so it wouldn't slide. I was bringing potato salad to the event where my parents had planned to remove me from the family. They did not tell me that part in advance. My name is Naomi Voss. I am 36 years old. I live in Charlotte, North Carolina, with my husband Duncan, who teaches history at a public high school and makes very good coffee at 7 in the morning. I work at Hargrove & Klein, a civil litigation firm in Uptown Charlotte, where I have been a paralegal for 9 years. What that means, practically, is that I read legal documents for a living, case filings, motions, discovery packets, opposing counsel submissions. I read them the way other people read text messages. Fast, looking for the thing that matters, finding what the person who wrote it hoped I would miss. I had been doing this for 9 years. I was good at it. I did not know, when I loaded that potato salad into my car on a Saturday morning in June, that I would need to be. They assumed I would read the lawsuit the way they assumed I read everything. Cautiously, 1 page at a time, afraid of the number. They assumed $340,000 was large enough to stop a person from thinking clearly. They assumed that announcing my removal in front of 120 relatives meant I had no resources left. They forgot that I read exactly these documents every day. They forgot that finding exactly these errors is what I am paid to do. They forgot that I had read the first 20 pages before I left the parking lot. The folder was in my hand before the afternoon was over. Let me tell you who Colette is first, because nothing about that Saturday makes sense without her. Colette Voss is my older sister. She is 39, and she has been the organizing principle of our family's emotional life since approximately the year I was born. She is not cruel. That is important to say. She is the kind of person who occupies the center of a room by natural gravity, who gets the Christmas earrings every year because she mentioned liking them once in October, who ran the family business with the kind of visible effort that parents love to point to and say, "That one. That one has the drive." The business was a home staging company my parents helped us start in 2015, a joint venture between me, Colette, and our younger brother Ferris. Though Ferris put in 6 months of work and then discovered staging was not for him and quietly redirected his energy toward his VAC certification, which left me and Colette. And for 3 years that worked. I managed the books and the contracts. Colette managed the client relationships and the jobs. We built something real. By 2018, we were billing $280,000 a year and had 4 part-time employees. In 2019, I left. It was not a falling out. It was a decision I made after accepting a full-time position at Hargrove & Klein, which I had been working toward for 2 years. I told Colette 6 months in advance. I drafted an exit agreement with the help of a notary. A real document, witnessed, signed by both of us, dated March 14, 2019, that transferred my ownership interest to Colette and removed me from any ongoing liability. I kept a copy. I put it in my filing cabinet at home, in a folder labeled Voss Staging/Exit behind the tax returns. Colette took over. For 3 years, it went fine. Then, it didn't. The reasons are complicated, and I was not there to see them unfold, but the short version is, she expanded too fast, hired the wrong project manager, lost 2 anchor clients in the same quarter, and ended the year $340,000 in the red. The business closed in January of this year. In March, I received a certified letter. Colette's attorney had filed a lawsuit naming me as a current managing partner of Voss Home Staging LLC and claiming I bore partial liability for the company's losses. The business filing, it turned out, had never been formally updated. My name was still on it, not because of a mistake on my part. I had signed the exit agreement. But nobody had filed the amendment with the state. Colette's attorney had found a current filing with my name on it and used it. I did not know any of this when I made the potato salad. I knew there was a lawsuit. I had not yet read it. My own attorney had advised me not to read it until we had a strategy call scheduled for the following week. My parents called me the Tuesday before the reunion and said they were hosting a family gathering. Nothing unusual about that. We had done these before, summer cookouts, holiday lunches. I asked if I should bring anything. My mother said, "Bring something to share." I brought the potato salad. I grew up watching my mother navigate this family the way a hostess navigates a party. She managed the temperature of every room. She knew when to speak and when to redirect. She knew who needed to be soothed and who needed to be distracted and who needed to be allowed to feel important so that the larger structure could stay intact. She was good at it. She had been doing it for 40 years. What she was not good at was honesty about the cost. The pattern had a name I didn't have for it until I was an adult. It was called management by accommodation. You figure out which person in the system is most difficult to manage if they are unhappy, and you make sure they are not unhappy, and the people who are easiest to manage absorb whatever is left over. In my family, Colette was difficult to manage when she was unhappy. I was easy to manage regardless. The math was simple. When I was 12, Colette had a science fair project due. She had not started it. She came to my mother 2 nights before the deadline, and my mother came to me and asked, very gently, if I had anything Colette could adapt. I had a project on cloud formation I had done the month before. I handed it over. My mother thanked me with a smile that meant, "You are the easy one. You understand." At the time, I thought this was a compliment. Colette won 3rd place. My mother put the ribbon on the refrigerator. When I graduated from paralegal certification in 2016, my parents took me and Duncan to dinner at a steakhouse in South Park. My father ordered wine. My mother gave a small toast. It was a real moment, and I appreciated it. Then, my mother mentioned, 3 times over the course of dinner, that Colette was really finding her groove with the staging business. Colette was not at the dinner. She was at a client event. She was mentioned more than I was at my own celebration. I ordered the salmon and let it go. At Colette's wedding in 2021, my father gave a toast. It was 7 minutes long. He talked about Colette's determination, her entrepreneurial spirit, her willingness to take risks. He talked about the family business in a way that made it sound like her idea alone, her construction, her legacy. He mentioned me in 1 sentence, and of course Naomi helped in the early days. Duncan squeezed my hand under the table. I took a sip of champagne. I almost stood up. I had the thing I wanted to say right there, 4 sentences, starting with Dad. I ran the books for 4 years. Then, the DJ started and the moment passed, and I ordered another champagne, and we danced, and that was the wedding. And that was how it always went. At Christmas in 2023, my parents gave Colette a pair of pearl earrings, $1,200. The box was from a jeweler on Park Road that my mother had mentioned wanting to visit for years. They were beautiful, white freshwater pearls, graduated, the kind that go with anything. Colette held them up for the room and everyone admired them. She put them on right there, standing next to the Christmas tree. I received a gift card to a restaurant Duncan and I liked. $75. I thanked them, and meant it. We went to the restaurant in February and I had the short rib and Duncan had the salmon, and it was a very nice evening, and I thought about none of this. These are not catastrophic events, they are small ones. But small ones have a weight that accumulates differently than large ones, and by the time you feel the full sum, you have been carrying it for so long that you don't remember setting it down ever being an option. What I understood by the time the reunion came around was this: I was not the person my family was going to protect. I was the person they had decided, long before any of this, could absorb the cost of protecting Colette. That decision had been made in increments over 30 years, through ribbon placements and omitted sentences and $75 gift cards. The reunion was just the first time they said it with a microphone. The reunion was at a rented event space in Concord, about 30 minutes from my parents' house. It was a Saturday in late June, 90 degrees by noon. When I arrived, the parking lot was already half full. I recognized cars belonging to my Aunt Iris, 3 cousins from my father's side, and my grandmother's neighbor, who comes to everything now because my grandmother passed in 2022 and nobody had the heart to take her off the list. I carried the potato salad inside. The tables were arranged in a U-shape around a small stage area, the kind that venues have for presentations or DJ setups. There were name cards at each seat. I found mine at the far end of the left table, separated from the main family cluster by 2 empty seats. I picked it up, looked at it, put it in my pocket. Duncan was not there. We had driven separately because I came directly from a deposition prep session that morning. He was expecting to meet me there by 1. At 12:50, he texted, running 10 minutes late. "Save me a seat." I texted back, "Just get here when you can." The food table had cold cuts, 2 pasta salads, a fruit platter, and a sheet cake that said "Family Reunion" in blue frosting. I set my potato salad at the end of the table and looked for the serving spoon. There wasn't one. I made a mental note to ask someone. I never got to it. Colette was at the front of the room near the stage, wearing a cream-colored linen dress and the pearl earrings from Christmas. She was talking to 3 cousins and laughing at something. She did not come to say hello when I walked in. She looked up once when I entered, made brief eye contact, and looked back at her cousins. The look lasted less than a second and told me nothing except that she knew I had arrived and had already processed that information. My brother Ferris, 34, HVAC technician, was near the food table with a plate already loaded. He nodded at me. I nodded back. That was the extent of our greeting. My mother was behind the stage area talking to the venue coordinator. She had a clipboard. She smiled at me from across the room, that specific smile I had learned to read over 36 years. It was the load-bearing smile. It was holding something up. I sat down at my seat. The 2 empty seats beside me stayed empty. Around the room, relatives I had not seen in 18 months were catching up, passing dishes, taking photos. The room had the warm, circular energy of family gatherings. Normal. It was very well done. I see that now. The normality was the setup. At 1:15, my mother took the stage. She welcomed everyone. She thanked them for coming. She said this family had been through a difficult season, and she and my father had called this gathering to address some things directly, which they believed was the honest way to handle family matters. She said this with the voice she used when she was presenting something difficult as something principled. She had practiced it. I could tell by the way she breathed through it, the measured pauses, the eye contact spread evenly around the room. She had practiced in front of a mirror or in front of my father, and she had gotten it smooth. She said, My sister Colette had carried the family business alone for 3 years and had been left with $340,000 in losses that were partly the result of my early departure. She said. They stood with Colette in the legal matter that had been filed. She said. They were asking me to take responsibility for my part in what happened, and until I did, they would be stepping back from our relationship. She said all of this into a microphone to 120 people, with the steady voice of a woman who had rehearsed it. I sat at the end of the table and listened. I was aware of people turning to look at me in small, sideways increments, the way people look when they are not sure if they are allowed to look. One of my father's cousins, a woman I had met twice, was biting her lip. My Aunt Iris had stopped moving entirely. A child at the far table was asking his mother something in a whisper, and the mother was not answering. My father walked across the room. He was holding a manila folder. He held it out to me without making eye contact. I took it. Ferris said, "Take the trash with you." He said it quietly enough that the far tables probably didn't hear it, but the people within 10 feet heard it. I saw 2 of them exchange a look. I stood up. I picked up my purse. I walked to the food table, got my glass bowl, put the lid on the potato salad, and walked out. Nobody stopped me. A few people looked at their plates. My Aunt Iris tracked me to the door. In the parking lot, I sat in my car with the folder on the passenger seat and the potato salad in the back. I opened the folder. I had read 43 pages of a civil litigation complaint, with a pen in my hand and margin notes in blue ink, before Duncan pulled into the lot beside me. Here is what I found in the first 20 pages. The complaint named me as a current managing partner of Voss Home Staging LLC. The basis for the claim was a 2023 business filing with the North Carolina Secretary of State that listed my name as a principal. The filing was accurate. Technically, my name was still on it. What the complaint did not mention, because Colette's attorney had either not looked for it or hoped I had not kept it, was the exit agreement dated March 14, 2019. That document transferred my ownership interest in full. It was signed by both of us. It was witnessed by a notary. It predated every financial decision that led to the $340,000 loss by more than 3 years. I want to explain what I do for a living because it matters to what happened next. A civil litigation paralegal is not a secretary. I manage the working infrastructure of active lawsuits. I prepare discovery requests, draft motions, organize evidence, review opposing counsel's filings for procedural errors, and maintain the case timeline from initial filing through trial or settlement. I have been doing this for 9 years at a firm that handles 20 to 30 active civil cases at any given time. I have read, in detail, more than 200 civil complaints. A civil complaint is a specific legal document with specific requirements. It must correctly identify the parties, accurately state the factual basis for the claim, and attach or reference supporting documentation. When a complaint names a party as a current managing partner of a business, that designation has to be accurate as of the date of filing. If the person resigned from that role in writing, with a witnessed exit agreement, 3 years before the losses in question occurred, the complaint has a fundamental problem. It is not a minor problem. It is a problem that a motion to dismiss can address within 48 hours if the documentation exists and the paralegal reading it knows what she is looking at. I knew what I was looking at. I had been doing this job for 9 years. I had read 200 complaints, and sitting in the parking lot of that event venue with my margin notes in blue ink and the potato salad in the back seat, I understood something my family did not understand, and Colette's attorney had apparently not checked. The exit agreement I had filed away 3 years ago was not just a personal record. It was the end of the case. A civil litigation paralegal who has processed 200+ cases knows what a motion to dismiss looks like. She knows what grounds are required. She knows what documentation needs to be attached. She knows how long it takes to draft one when the evidentiary basis is already in hand. I had the evidentiary basis in my filing cabinet at home, 3 years old, gathering no dust at all. Duncan pulled up next to me. He looked through the passenger window at the folder in my lap, the pen in my hand, my face. He got out of his car and came around and knocked on my window. I rolled it down. He said, "What happened?" I said, "I need to make a call in the morning." He said okay, and he got back in his car and followed me home. In the car, I had almost turned around twice. Once at the exit of the parking lot, when I thought about going back inside and saying something. I had a version of it ready, a calm version. A version that used the phrase exit agreement, dated March 14, 2019, in the first sentence. Then I thought about the 120 people in that room, and the microphone, and my mother's rehearsed voice. And I understood that the room had already been arranged before I arrived, and that going back inside was going back into an arrangement someone else had made. I kept driving. The second time was on the highway, about 15 miles from Charlotte, when Ferris's name appeared on my phone screen. I let it ring. He did not leave a voicemail. I thought, he is either calling to apologize or to repeat himself, and either way I don't have a response yet. I didn't need a response. I needed to get home and read the rest of the complaint. Here is what they thought I would do. They thought I would call my mother that evening shaken. They thought I would ask what I needed to do to fix this. They thought the $340,000 figure, said into a microphone in front of 120 people, had created enough pressure that I would be looking for the fastest way out of it, which in their model was compliance. They thought removing me publicly would destabilize me enough that I would make decisions from that instability, the way people do when they are cornered and frightened and trying to stop the bleeding. They forgot that I work in a law firm. They forgot that I spend my days watching people try to do exactly what Colette had done, and watching the attorneys I work with find exactly the kind of documentation I was already holding. They forgot that the first thing a civil litigation paralegal learns is the document is the answer. Not the argument, not the pressure, not the public announcement, the document. They forgot I had the exit agreement in my filing cabinet. They forgot I had read 43 pages with a pen in my hand before I got back on the highway. They forgot that I filed things by date and by category and by the specific future in which I might need them, because I had been doing this professionally for 9 years and personally for longer. My mother had asked me once at a holiday dinner what I actually did at work. I had said, I read documents and find problems before they become permanent. She had nodded and changed the subject. She was not wrong to ask. She was wrong about whether the answer mattered. At home, Duncan made tea and did not ask questions until I was ready. I sat at the kitchen table and finished reading all 43 pages. I made notes on a separate legal pad. 8 substantive issues with the filing. 3 procedural problems. The exit agreement alone was sufficient for a motion to dismiss, but there were other angles worth noting. Duncan sat across from me with his own tea and his Sunday school lesson plans, and we worked in parallel the way we always did, without needing to explain ourselves to each other. At one point, he got up and made toast and put a plate in front of me without asking. I ate it without looking up from the legal pad. At 10 p.m., I almost called my mother. I had her name on the screen and my thumb on the call button. Then I thought, what is the conversation? What is the version of this call where something useful happens? She would be sorry, or she would explain, or she would ask me what I needed to do to resolve it, and I would not be able to answer any of those things correctly at 10 p.m. on a Saturday with 43 pages of margin notes in front of me. The call would be about emotion, and I was not in a place where I could manage emotion and documentation at the same time. I had made that mistake before, in smaller situations, and it had cost me the clarity I needed. I put the phone down. Duncan looked up. I said, I'm going to call Celeste in the morning. He said okay. He went back to his lesson plans. At 11 p.m., I put the complaint in the folder. I put the folder on top of my bag for the morning. I went to bed. I did not sleep well. But I did sleep. At 7:04 on Monday morning, I was in my office at Hargrove and Klein. Celeste Abrams is 44, senior associate, 14 years at the firm. She is the person who trained me when I joined 9 years ago, and the person I trust most in any legal context. She is also the person who, on a Monday morning before her first coffee, can read a situation faster than anyone I have ever worked with. I put the folder on her desk. I told her what had happened. She listened without interrupting. Then she picked up the complaint. She read for 4 minutes in silence. She set it down and said, "Send me the exit agreement and the business filings by tonight. I'll have the motion drafted by morning." That was it. That was the entire conversation. I sent her everything by 6 p.m. By Tuesday at noon, she had filed a motion to dismiss with prejudice, attaching the exit agreement and a certified copy of my name's current status on the business filing, along with documentation of when the state filing had last been updated and by whom. That last piece is where the depth of what Colette had done became clear. The business filing with the Secretary of State had been updated twice since I left in 2019. Colette had filed both amendments herself. The second amendment was dated August of this year, 6 weeks before she filed the lawsuit. She had updated the filing twice and left my name on it both times. This is not the kind of thing that happens by accident. You do not file a business amendment and accidentally include a name that has not been accurate for 3 years. You either update the name or you leave it. Leaving it is a choice. Leaving it twice, including 6 weeks before filing a lawsuit that relies on that name appearing on the document, is a specific kind of choice. Celeste included this in the motion. She did not editorialize about it. She simply documented the dates. Exit agreement March 2019, filing amendments September 2021 and August of this year, lawsuit filed 6 weeks after the second amendment. The timeline spoke. I was at my desk when she walked over and set the filing confirmation on my keyboard. I put it in the folder. That was the thing I had not let myself fully consider during those 43 pages in the parking lot. I had been focused on the exit agreement, on my own documentation, on what I could prove about what I had done. I had not yet thought carefully enough about what the filing amendments showed about what Colette had done. By Tuesday, when the motion hit Colette's attorney's desk, he would have seen it too. He would have called her. That conversation is one I was not in the room for, but I can construct it from what followed. He would have told her that the filing amendment timeline was now in the court record. He would have told her that continuing the lawsuit meant arguing that a name retained through 2 deliberate filing updates was an oversight. He would have told her that the exit agreement, dated 5 years before the lawsuit, made that argument very difficult to sustain. She dismissed the suit 3 weeks later. The $340,000 was still hers. I think about what she was doing when she filed those amendments. I think she was managing risk in the way people manage risk when they believe they will never have to answer for it directly. Keep the name there. It costs nothing. And if things go badly enough that you need it, it's there. What she had not accounted for was that the person whose name she was keeping would be a civil litigation paralegal who read the complaint in a parking lot with a pen in her hand. She had never once asked what I did at work. On Sunday, the family group chat had come alive. I read it twice and then muted it. There were 12 messages from relatives I had not spoken to in 2 years, most of them variations on hope this gets resolved soon and thinking of you all. My Aunt Iris sent a separate text directly to me. She said, "I'm sorry about Saturday. You handled that better than I would have." I sent back a thumbs up. I could not think of anything else that was appropriate. Ferris texted me Sunday evening, "You should just pay it. Save everyone the trouble." I almost wrote back. I had something ready, 3 sentences, the kind of precise 3 sentences I write at work when someone on the opposing side has misstated a fact I can document. Then I thought about what 3 sentences would actually accomplish with Ferris, and I put the phone down. He did not need the information. The court already had the information. I did not respond. On Monday evening, my mother Evelyn left a voicemail. She said she hoped we could resolve this as a family and that she was available to talk whenever I was ready. She said as a family twice in a 40-second message. I listened to it once and archived it. My father Gerald did not call at all. That was its own message, and I heard it. On Tuesday morning, something changed in the shape of the incoming communications. The family group chat went quiet. Ferris did not text again. My mother did not call. I know what happened Tuesday because Celeste walked me through the likely timeline afterward. The motion to dismiss, along with the attached documentation, had landed on Colette's attorney's desk sometime Monday afternoon. He would have read it Monday evening or first thing Tuesday. He would have called Colette Tuesday morning. That call would have covered the following: the exit agreement predated the losses by 5 years. The filing amendment timeline was now in the court record. Continuing the lawsuit meant arguing against documented, witnessed evidence of Naomi's departure from the company, and doing so while the court could now see that the filing showing her as a current partner had been updated twice. Most recently 6 weeks before the lawsuit was filed. He would have told Colette what her realistic options were. Whatever that conversation was, she called our parents Tuesday evening. My aunt texted me at 9:15 that night, "Colette has been on the phone for 2 hours. What's happening?" I sent back, "Let me know if you hear anything." I already knew what was happening. I just did not know how long it would take for the family to understand what had already been set in motion. At 6:58 p.m. on Tuesday, according to my aunt's later text, my father had gone quiet at the dinner table after Colette's call. He had pushed his plate back and sat there. He had not said much for the rest of the evening. My mother had made tea, and they had sat at the kitchen table the way couples sit when something has broken, and neither of them is sure yet how large the break is. By Wednesday morning at 8:43, my mother was at my door. I heard the knock while Duncan was in the kitchen making coffee. I came out of the bedroom and he was already in the hallway, looking toward the front door. He looked at me. I looked at him. I went to the door. My mother was standing in the hallway outside my apartment in the kind of clothes you wear when you leave the house faster than you planned. No coat, even though the morning was cool. Her hair was not set. She had her purse over one shoulder, but both hands were clasped in front of her, the way she stood in church when the minister said something she needed to hold on to. She looked at me, and she said, "Naomi." I said, "Come in." She came in. Duncan brought a third mug without being asked and set it on the coffee table and went back to the kitchen and stayed there. Through the doorway I could see him at the counter with his back to us, very deliberately pouring coffee and not turning around. This is one of the things I have loved about Duncan for 11 years. He knows which rooms to be in. My mother sat down on the couch. She looked at her hands. She looked at the window. The apartment was quiet except for the sound of the neighbor's dog somewhere down the hall. She looked at me. Her eyes were red in the specific way they get after a night of not sleeping, and maybe after a morning of driving 30 minutes without calling first to make sure I would be home. She had come without calling. That told me something. If she had called, she would have had time to prepare what she was going to say. She had not called because she needed to arrive before she could talk herself out of it. She said, "We didn't think you'd actually fight it." I did not say anything for a moment. I let that sentence sit in the room. She meant it as an explanation. She was trying to say, "We misread you. We miscalculated." She was not apologizing, not exactly, but she was doing the thing she had never been able to do directly, which was admit that there had been a plan, and that the plan had been built around an assumption about me that was wrong. She was confirming, in one sentence, that the announcement at the reunion was not impulsive. It was strategic. They had staged it expecting me to absorb it the way I had absorbed everything else. I said, "Mom, I had the exit agreement in my filing cabinet. I left the business in 2019 with a signed document. I was never going to pay a lawsuit based on a filing that no one updated." She said, "Colette didn't know you kept it." I said, "I know." She looked at her hands again. Outside in the hallway, the neighbor's dog stopped. The apartment was very quiet. I said, "You announced this in front of 120 people. You handed me a folder in front of 120 people." She said, "Your father thought it would be better to be direct." I said, "Okay." She looked up. I said, "I'm going to need some time. This isn't something we can resolve in a conversation." She nodded. She picked up the mug Duncan had brought and held it in both hands and looked at the window. We sat like that for a while. She did not try to fill the silence with additional explanation, which was something. She usually tried to fill silences. After a while she said, very quietly, "You brought potato salad." I said yes. She said, "Nobody touched it." I said I knew. She left 20 minutes later. She hugged me at the door. A careful hug, the kind you give when you're not sure what you're allowed to hold. I held it for 3 seconds and then stepped back. I closed the door. Duncan was in the kitchen. He set a mug of coffee in front of me and sat across the table and looked at me the way he did when he was not going to offer any opinions until I asked for them. I said, "She said they didn't think I'd fight it." He said, "What did you say?" I said, I know." He nodded. We drank our coffee. I thought about what she had said. About Colette not knowing I kept it. About the assumption that I was the kind of person who did not keep things. Who moved through her life without filing away the documentation because she trusted people to be who they said they were, because she was the easy one, because she understood. I keep everything. I have kept everything since I was 24 years old and watched my parents sign over a $28,000 business loan to Colette based on a handshake and a verbal agreement and thought, if that were me, there would be nothing on paper. I went home and opened a filing system, and I have not closed it since. The easy one keeps receipts too. They just don't advertise it. Colette's attorney filed a motion to voluntarily dismiss the case 3 weeks later. The exit agreement, along with the procedural deficiencies Celeste had identified, made the suit untenable. The $340,000 remained Colette's problem. The judge signed the dismissal order on a Tuesday afternoon. Celeste walked it over to my desk and set it down without a word. She had worked with me for 9 years. She knew I didn't need the speech. I put it in the manila folder. I have thought about what Colette believed she was doing. This is important to say, because she is not a cartoon. She is a person who ran a business alone for 3 years after I left and watched it fail, and who arrived at the lawsuit the way people arrive at bad decisions, through a series of smaller decisions that each seemed reasonable in the moment. She believed she had done more work than I had. She believed my departure contributed to the failure. She believed my name on the filing was a fact, and facts are permissible in lawsuits. She had an attorney who advised her that the case had merit. She had parents who agreed with her. What she did not do, in the course of building that belief, was call me. She did not call to ask what I had kept from when I left. She did not call her attorney and say she was a civil litigation paralegal for 9 years. What does she probably have in her files? She did not do any of the research that would have told her the exit agreement existed and that the lawsuit would collapse the moment it was filed. That omission is not carelessness. That is what happens when you have spent 30 years in a family where one person is the capable one and the other person is the one who understands. You stop checking whether the other person has resources. You assume the answer in advance. She assumed wrong. My colleague Marcus Webb, a paralegal in our contracts group, stopped me in the break room 2 weeks after the dismissal was filed. He had heard something through the firm grapevine. He said, "Was that your family?" I said yes. He said, "You good?" I said yes. He said, "I would have been a mess." I said I had been at it long enough to know that the paper is steadier than the feeling. He laughed and poured his coffee, and we went back to our respective files. I had absorbed things. I had let them go. I had been the easy one for 36 years. But I had also, for 9 years, been doing a job that required me to treat paperwork as the final word, and I had brought that habit home with me so thoroughly that it had become the shape of my own domestic life. The filing cabinet in our second bedroom has 17 hanging folders. They are organized alphabetically. The folder marked Voss staging/exit has been there since 2019. It is not thick. It does not look important. It holds one document and one notarized copy. That one document was sufficient. I think about the fact that Colette has never once, in 9 years of sibling dinners and holiday visits and Christmas earrings, asked me what I actually did at work. My mother asked once and changed the subject. My father has never asked at all. Ferris knows I work somewhere downtown with lawyers. The whole family's picture of me was assembled a long time ago, and they stopped taking new photographs. That is the thing about being the easy one. People assume your stillness means you are not moving. They read the absence of drama as the absence of capacity. They see you carry things quietly, and they assume you are carrying them out of helplessness, not out of patience. They assume that if you were really capable of something, you would be louder about it. They forget that the people who know exactly where the exit agreement is are rarely the ones making the scene. 6 weeks after the reunion, I am at my desk at Hargrove and Klein. 14 open files. 7 active litigation, 3 in discovery, 4 in motion practice. The window faces north. Outside, Charlotte is going about its business. The coffee shop across the street opened 40 minutes ago, and there is a line out the door. The manila folder is in my filing cabinet. Same drawer as the exit agreement. Same drawer as the tax returns and Duncan's teaching contract and the lease agreement and everything else that has needed to be kept. The drawer closes with a particular sound, a soft, specific click. My grandmother used to say, "The woman who knows where the papers are is the woman who survives the meeting." I did not know what that meant when she first said it. I was 11. I know what it means now. If you have ever been the quiet one in the room, the one who brought the potato salad, The one they didn't think would fight it, they are wrong about you. The filing cabinet is the answer. Document everything, keep the copies. Wait for the right moment to open the drawer. Leave a comment if this reached something real in you. Share it with someone who needed to hear it. Thank you for listening to Family Secret Tales. There is more where this came from, and I will see you in the next one.